Once again, we gather in search of the truth, dark, and mystery. It's the Drunk Turkey Show.
Big development today in the investigation into the murders of 4 University of Idaho students. According to state and local officials and court documents, 28-year-old Bryan Kohberger has been arrested. He was arrested and arraigned this morning in Pennsylvania.
We have new details on what Bryan Kohberger was doing right before his arrest. Police says a tactical team burst in to arrest the Idaho murder suspect. He was in pajamas and latest gloves, stuffing trash into Ziploc bags.
Hey, greetings from the year 3000. It still sucks. This is Philip J. Pride, and you're listening to the Drunken Turkey Show. Your one stop for this sort of thing. Hit that button, like and subscribe. You know what to do, just like every other podcast.
Just like every other podcast. What is up, everybody? Welcome back to the Drunk Turkey Show. I'm Daniel. We got you guys last night. We're going to be on tonight, and we're going to be on tomorrow night. So you're going to get the trifecta of Drunk Turkey shows. Last night we talked about the Richard Allen case. Today they had closing arguments, and tomorrow we'll be also talking about the Richard Allen case and have on It's a Criming Shame, who's been covering the case for quite a bit of time. They're going to come in and talk to us about, the case and the trial that's going on with Richard Allen. And who knows, maybe there's a verdict by the time that show starts. So you might want to hit that like button, hit that subscribe button, ring that notification bell. Also, don't forget, guys, of our partnership with Data Seal. So if you're concerned about things, being out on the web, so search yourself and you'll see how much of your personal information is out there. If you're concerned about that, check out Data Seal. They'll wipe off those things from the interwebs, and that includes things like your religious beliefs, your political beliefs, and so much more. Your personal information, phone number, addresses, and more. Check out the link in the description. It is Data Seal. You get a 5% discount when you use the link. All righty, so back to the content. So Bryan Kohberger had a hearing today, and a lot of it had to do with the DP. And my first impression, so I've seen the hearing twice, and my first impressions were that this judge, Stephen Hippler, is no nonsense kind of guy, and I think that he is able to control this courtroom in a way that just judge couldn't. It felt like in Moscow that judge was kind of allowing things, even if he knew or thought that they wouldn't go anywhere, or, it's kind of, I think at one point he said it was futile, but that he would still allow some of these arguments and that to be heard and said. And Hippler's just biting them in the rear, nipping them in the rear as they're coming through, correcting the defense at every moment when they're being inaccurate or trying to, what's what I'm looking for, trying to drop bombs or whatever you want to call them. So what I've done is we're going to pull up the hearing. We're going to talk about it. We're not going to go through all of it. Nowhere near any of that. We're going to look at the highlights. I got some stuff highlighted. We'll talk about what they are. And, I've said it for a while. Bryan Kohberger, careful what you wish for. You just might get it. And he was the one that was wanting to get out of Moscow, Idaho, so changed judge. And, well, be careful what you get for, my man. So let's see. Oh, guys, also, I would recommend going and checking out my X, Twitterverse, whatever you want to call it, x.com. Handle is at Drunk Turkey Show. I think I put up a pretty funny post up earlier. I want you guys to go check. Let me know what you guys think when you go and see it. All righty. So first and foremost, I did notice that there was a new, prosecutor attorney here in the middle. And I'm not familiar with who she is. I really haven't had an opportunity to go back and research who this person is. Maybe perhaps this person is, has been on the case before, but I've just never seen them. Maybe they've been listed and I don't know who they are. But I don't see Bill Thompson out here. Now, I know there's some questions as to where he was and why he wasn't here. I have no idea. One of the things that I think is a possibility is that he was put on the Brady list or the Brady Giglio list or whatnot. And I think maybe that might be a reason why he's not there. The reason behind why he was on that list is because it really has nothing to do with him. It was a situation where a lady had it was in a relationship with somebody who ended up being violent with her, and he ended up going, I think, to prison or to jail or something like that. He ended up getting released, and the victim wasn't notified, and so she filed a complaint against the county of Latah County, which it all ended up falling on him. Not necessarily certain if that's his job to notify people when persons are supposed to be exited, but when you are the head of the position that you're in, it falls back on you. So I think that might be a situation why he may not have been there, but I have no idea, to be honest with you. But let's get into this. Let's talk about it. For the most part, the defense wanted to get rid of the DP, and let's just watch it. I do have this sped up, which it's gonna, just because it's way too long, but I'd have it sped up a little bit. Oh, y'all can't hear it? Sorry about that again. All right. And we're not going to go through all 4 hours. It's not sharing the right way. It did this to me last time. I pushed that here with the sound. All righty. So let's start that back up a little bit.
Executing anybody. When somebody sits on death.
So what they're saying, just basically what she's saying, is that the reason why they shouldn't, have this shouldn't be a death penalty case, because currently, in her opinion, there isn't a current way or means of taking the life of a person that's on death row. And so the prosecution comes back with a very, very good, and including the judge comes back with a very good argument, kind of talking about, well, what difference is that going to make now, versus what it will make later? Like, perhaps you don't like the fact that they have chemicals today. You don't like the fact that the backup plan would be the firing squad, but these guys aren't going to be going to trial anytime soon. They both, and all of them, agreed that this could take a decade or longer before the actual settlement or the actual what's the word, the sentence is served, meaning that they take away Bryan Kohberger's life. And one of the arguments that the state says is that you can't just say, hey, you don't like the way it is now, and without knowing what could happen in the future. And they break it down pretty good. And there's a lot of other things that they break down, but it's interesting. And I'm going to put it at one part as well, when they talk about an alternative means of taking his life.
Death row, and there's no real means of executing them. That is dehumanizing to that person. That's similar.
Say there's no means under Idaho law. The method of execution is lethal injection, and if unavailable, then the firing squad. You rely significantly on the idea that lethal injection is not available based upon the quote-unquote botched execution of Mr. Creech. It seems to me that was a particularized incident wherein Mr. Creech, the execution really hadn't even begun yet, in the sense that they couldn't locate a vein. I don't see how that issue is universal.
Boom. And, to me, there was a lot of times where Judge Hippler was, it sounded like he was arguing against the defense as if he was the prosecution. And when he brought up the prosecution up for rebuttal and things of that nature, his questions to them were kind of not, I wouldn't say there were softballs or anything like that, but there were kind of like, well, what do you say about this? And then he would bring up his own interpretation of what it was that he thought that law meant, and then he would ask for the opinion of the prosecutor. And I just thought that was an interesting way of doing it. It just kind of seemed like he was trying to, it's like he felt that maybe perhaps knowledge of the law maybe isn't to his expectation when he's looking at some of the briefings and some of the things that they're being argued back and forth. So I just thought that was interesting. So you guys will see that interaction.
I would agree that Mr. Creech's, the situation that happened to him was unique to him. I don't think he's the only person that has ever had that happen. I'm not in the state of Idaho, but I think that that's happened before when the means of execution couldn't be employed at the time. But since we're talking about Idaho, I think we should look at what happened in the Pizzuto case too. And in that case, there was no ability to obtain the chemicals to kill him with. And so his execution, his death warrant expired without him being executed. After that happened, Idaho passed legislation that would allow the Department of Corrections to obtain the chemicals to kill somebody in secrecy. After that happened, there's still a lot of difficulty getting the chemicals because pharmaceutical companies don't like to have
They have obtained them twice now, since then.
They've obtained them twice for Creech, yes. Now, something has changed in the death chamber or how they will try to execute Creech. I don't know what that is. That's probably one of those things.
Creech was, I think, sentenced in the 90s or something like that, 80s. And they'll bring it up when his sentencing is finally being executed. So she's arguing about the current status of the execution law in Idaho and how it portrays to her client that by the time that his sentencing is executed, is probably going to be a lot different than what we would expect it would be today. And they bring up an interesting point that as things change, it's not like they have to stay the same, that they brought up a situation where a person was sentenced for his life to be taken, and it was going to be by a rope on a tree. And during that time, while he was waiting for that sentence to be executed, the United States had an agreement that it would switch to electrocution. And so at that point, they had allowed this person to then get the chair versus getting the rope on a tree. And so there's nothing saying, what they're arguing is that we're not, or the prosecution isn't arguing the method. They're just wanting to present the sentence. The method aspect is going to be taken care of in a few decades, or not even a few, maybe a couple of decades, maybe a little bit less. But to me, these arguments that they make today, it's not necessarily majority of it is against things in particular to Bryan Kohberger. It's more that they don't agree with the death penalty, period, and that it's unconstitutional, yada, yada, yada. Not really arguing anything in specifics until a very small part where they bring up Lori Vallow and judge shoots her down there again, basically saying that the situations in the Lori Vallow case is much different than the situation with the Bryan Kohberger case. And so it's their argument here, in my opinion, is just it's weak. And let's see how she responds to this.
That we'll learn a little bit more about through Creech's.
I think that they're going to utilize a central venous catheter. In other words, accessing a central vein rather than a peripheral vein. My understanding that there's federal law approving a procedure, as well as a recent decision by the district court approving that procedure. I think that's the difference.
So he just dropped the bomb on her, saying, hey, I understand that you're going back and you're trying to look into the past at one specific time, but since there's been other precedent, and that precedent is now, or those things that happened since the time that she's referring to, that's the ongoing method of doing things, and they didn't take away the sentence; they just were waiting for the method. So let's move forward a little bit. Right. So when the prosecutor or the defense argues that they believe that the death penalty is inhumane or whatever the case may be, they have to come back with an alternative. And let's watch how they handle
What
this.
a person is conscious and aware of when they face the firing squad. That's information that's important for the court when considering whether or not to strike the death penalty, because Idaho's means of execution really doesn't exist. Thank you, Your Honor.
Can I ask you, even if your motion were right, and
I'm gonna put this in regular motion so we can see how this went. I mean, in regular speed.
even accepting as true that the current means of execution are either unavailable or would violate the Eighth Amendment as cruel and unusual, how do you get around Buckwell? You've not provided a alternate means of execution.
That's a long pause. So let me pause that now. Basically, in Idaho law, when you say that, all right, the death penalty is unconstitutional, and you have the argument that, hey, this is unconstitutional, you have to bring up an alternative method of how you plan on going forward with the executing the sentencing. And so that was a long pause. I wanted to make sure everybody understood how long of a pause that was. And let's hear her response. Let me just rewind that a little bit.
How do you get around Buckwell? You've not provided a alternate means of execution.
Well,
Bryan Kohberger looks at it like, what?
And I know, and I understand.
You have to do that?
Perspective, it's not something defense counsel wants to do, is to say, no, do it this way. Execute my client this way. But Buckwell provides that if you're going to challenge the means of execution, you have to, as a condition precedent, provide a available or an alternate, I should say, means of execution.
I would say, to Your Honor, that we're not at the place where we would have to make that decision yet.
That speak to the justiciability of the issue.
That then brings up an interesting point. Is he asking her to come with something like, hey, no. What he's saying is, if you feel that this is unconstitutional or that these methods are inhumane and violate the cruel and unusual punishment, then what method do you suppose that you have that you can bring up that is less painful, less shocking, less any of these things? Like, we understand what you think. They're not going to change their mind on the death penalty today or on this case or anything, those things. And he's not going to go into it and try to say, all right, I'm going to, I myself is going to, make it precedent that the death penalty is a cruel and unusual means to an execution of a sentence. And, so what he's saying is, all right, where is your other method? And the fact that she doesn't know that she was supposed to do that, because the prosecution brought it up. When they went to rebuttal this entire, which I probably should have let it play because it was extremely weak defense, their appearance there, their demeanor, like when it was in Moscow, Moscow, Idaho, and Judge seemed to kind of be like it seemed like the defense team was like the alpha and Judge was the beta, and he was just kind of bowing down to them. It seems like roles are reversed between judge and defense here. So let's continue this real quick.
Overall,
I don't think it does. And I think that the separation and the difference is that we are in a place where we're preparing this case to go to trial. We represent Mr. Kohberger, who sits there, an innocent man right now, but we're preparing this case as a capital case with all of the things that involves.
So the one thing that this tells me also is, I know a lot of people are going to say, well, do you think Bryan Kohberger is behind all this? Maybe that's why she doesn't know these things. I don't know about that. Could it be that maybe perhaps all eyes are on this hearing, and if she can get something to change as big as the death penalty and having that thrown out, especially now before our administration changes hands or whatnot, I think that at that point, she wants to get this taken care of now, so that way it's not as more open later based on the administrations that'll be in place. And in fact, they bring that up to themselves. Sear says Brian ain't in Kansas anymore, peeps. No, he's not. No, he's not. There it is. Judge is definitely the better. Yep, 100%. Thank you, Sirius, for your $5 donation. We appreciate you. She's one of our mods, one of our members, and a huge supporter. Thank you.
All of the requirements that are upon council take a lot of time, a lot of work, and a lot of money to do this. And so I think when we're looking at the constitutionality.
So she's complaining about time and money and effort to do this, but they're the ones that are dragging their feet. And they become so hypocritical because towards the end of this, they start talking about, well, we had the right to, we weren't offered the right for speedy trial in some weird way because they had to choose the balance between an effective counsel and speedy trial. You didn't want to start then. You don't want to start now. So what difference is it making at this point? So these are just some of the things that we're going to see. It's super pathetic. I mean, I've been saying this for a long time, that the defense's plan of attack in this case has been one of a weak defense. In every instance, it's been throw mud on the wall and see what sticks. And in this scenario here, I can't put it past that. Maybe perhaps, like I mentioned before, or I started to bring it up, that maybe she sees that this is a good case that has her in the public eye. If she can make some crazy wild thing, maybe perhaps that'll, boost her, I don't know, ego or something. And she's going down this path where she clearly doesn't even know what she's supposed to do. Her first response is, well, after a pause for like 10 seconds, that tells you she was not prepared for a question like that. And if she was not prepared for a question like that, it's because she doesn't know. And, I mean, the judge came back with it pretty quick. Prosecution came back with it pretty quick. Only person that couldn't understand it or speak about it was Ann Taylor in the defense.
Of the execution, I think that's different than if there was a conviction and if there was a death sentence and if the post-conviction proceeding and the appeals were unsuccessful for Mr. Kohberger.
Doesn't that speak to your motion in the sense that you're saying take the death penalty off the table, don't let the state put on that evidence because the current methods, in your view, are either unavailable or unconstitutional. But the reality is if he is convicted, we know it's going to be a decade plus before that sentence would be carried out. And who knows what the methods may be then. And, I think that's part of why you're saying you shouldn't have to comply with Buckwell. But it seems to me that same rationale then applies to why I should even consider this motion. Why wouldn't we wait until that time frame to see what the current methods are? Who knows what technologically is going to be available at that time?
Boom. Like every argument that they had was shot down. The prosecution probably didn't have to even go up there and argue for themselves a rebuttal. In fact, there was a couple of occasions where they didn't, because the judge, so with conviction and confidence, that was one of the things that was lacking when it came to Judge. It just seemed like there wasn't the confidence in his decisions and his rulings. He felt uncomfortable with what he could and could not do and what his powers were. The defense even questioned him on a couple of occasions about what he can and can't do and what his powers are and are not. Whoa, that's a double not there. Either way, it's been already argued. I mean, it's been obvious that this entire situation has been this way. Now, like I said before, I thought this was a weak case from the defense. It's just that there was a judge who wasn't like this. And if he was, a lot of these things would have been struck down. I guarantee you, it probably would have gone to trial by now had Judge Hippler been the judge in Moscow right off the bat. That's my opinion. So let's move this forward to a little bit about they wanted to bring in a witness. And so let's go to that part real quick. So let's go. There we go.
Thank you.
So they wanted to talk about a witness and.
Your Honor, I'll try and keep this brief. I don't want to repeat much what's in my brief, and I think a lot has already been discussed today. But I want to start by pointing out, one of the things that Ms. Taylor just said was, looking forward, we don't have the answers to that yet. Well, that's the whole point. Is this just isn't right? We don't know what's going to be available.
Oh, this is the argument
It
still
probably
in
will be
this.
decades, plural. If you look at Idaho's track record, Mr. Creech, Mr. Pizzuto, they were convicted back in the 80s.
It is true, for the purposes of my question, that the state doesn't have a method. Should defendants be tried for and potentially sentenced to death when the state has no method of execution currently?
Yes, Your Honor, I don't see a problem with that, because deciding the method of execution is not deciding the sentence. The sentence is death. The method of execution is just how that's brought about. And so even the United States Supreme Court has recognized that someone who was convicted and sentenced to death, in that case, I believe was hanging. And then after he was sentenced to death, the state passed a law, made it electrocution. And the US Supreme Court said there's no ex post facto problem with that, because you're not changing the penalty. The penalty is death. And so even if you assume that Idaho cannot do lethal injection, and even if you assume that the firing squad is unconstitutional, that's not to say that decades from now, there is not going to be a method by which the state could put him to death. And then, of course, I was accepting the hypothetical as proposed, but we would strongly push back on this idea that Idaho doesn't have a method of execution. There was a scheduled execution to take place on November 13th, just days from now, that was only stopped because of a method of execution claim. And Bucklew, the court specific.
I just kind of want to just go quicker than that.
The distinction is not us being on death row with a death warrant that we're talking about. That's a different kind of conversation. We're well before looking at the overall picture and saying the Constitution protects somebody from sitting in prison when there's not a real means to execute.
So her whole argument is that it is inhumane to have BK on death row and not know the means of execution throughout the entire time that he's waiting. That is going to give him anxiety of not knowing how his life will end. At this point, get out of here. That's what he's worried about. Like, oh, how are they going to do it in 20 years or in 15 years? You would have assumed that there's probably going to be a more a different way than there is today. Because as the judge will bring up, and he's brought up, one of the issues when it comes to the chemicals is some of the pharmaceutical companies don't want to have anything to do with it. When we get their, understanding of why and how, but and the pharmaceuticals themselves, that's a different story and a topic to talk about at another time. But these arguments are really poor. And these arguments are things that, like, I question the purpose behind them. Like, what are you trying to do? Because you're not going, this isn't obvious, and he'll say it himself, that this argument is falling flat, as you would expect. And you would expect, them to have known something like this before they make themselves look this bad in front of the world.
I understand.
Case that says that.
I'm making an analogy with the troop versus duels and
that's one of that ones.
Warrant that we're talking about. That's a different kind of conversation. We're well before looking at the overall picture and saying the Constitution protects somebody from sitting in prison when there's not a real means to execute. I understand.
Case that says that.
I'm making an analogy with the troop versus duels and the denaturalization with the dehumanization that happens if somebody sits on death row when there's not a realistic way to execute. I understand that lethal injection has not been overruled. I understand that. But when we're talking about the recent history of what's happened in Idaho, there are problems, and there are real problems. We talked about Pizzuto, we talked about Creech, we talked about two pieces of legislation to try to.
All right, let's go with this. So at one point, so the new prosecutor lady that I'm not familiar with.
Subject of expert testimony. The state cited to Ybarra.
And I'll just say this. I mean, we're not going to listen to a lot, but this lady here is a badass. She goes in there. She's like, she's there. She's taking control of this with confidence. She sounds like what Ann Taylor was when the judge was judge. And I don't think the difference here is I don't think that she's trying to overpower Judge Hippler as much as Ann Taylor was trying to do that with Judge, in my opinion. She's just very strong in her convictions and how she says things, very smart and intelligent. I think that if you're going to replace Bill Thompson with anybody, this is a good choice.
In its objection, and in Ybarra, the Idaho Supreme Court held that legal conclusions by an expert were not proper for consideration before the court. Now, that expert was allowed to testify as to factual conclusions, but the court struck legal conclusions from that expert's declaration. Additionally, as the state also pointed out in its written objection, the Idaho Supreme Court straight up rejected a similar attempt to do an analysis over first-degree murder cases in an attempt to argue that Idaho's statutory.
So this is the we're going to fast forward this a little bit. So the defense allows, and look at Judge Hippler when the defense comes out. He does not hide his emotions. At the very end of the show, so you want to stick to him because he gives one of the best body language emotion that you can possibly see, and it's amazing. It's hilarious. But that'll be at the end.
But my first point to you today is that the United States Supreme Court wants what we're wanting to accomplish here today with Professor Cover. They want that discussion. So
I'll just kind of fill in the blanks here. There was a witness that the defense wanted to utilize that was going to show why, there was supposedly some sort of expert on the death penalty and a bunch of other things. And he just shot it down, basically said that she's not even an expert. Like, in order for him to have accommodated her, and it would have just been a big old mess. And this is the part where she comes in and basically tries to tell the judge that he's dumb. Watch, listen to this.
To occur so that the data is and studies are scrutinized and discussed, and a trial court like you has the ability to make a full assessment. Reading a paper doesn't allow you to do that the way that the expert who did the study can explain it.
So basically, he said that he can take into consideration the written down stuff. In the efforts for time, there was no purpose in having the quote unquote expert who he couldn't legally have her take the stand anyways. She's saying, well, you have this power. This goes back to when she was trying to dictate judge what powers he may or may not have. Again, it didn't work out so much or so well for her in this time.
The other point that I want to make is that as it relates to the Hairston case, I pulled the underlying briefing in that. So the underlying briefing in Hairston was a direct appeal and a post-conviction appeal, and they were consolidated. And the study that Dr. Jensen.
All right, she's going back into the study thing. That's not even going to be relevant. So let's go forward. What do I have here?
Is based on the cumulative effect of the aggravators together. It says you have to look at each individual aggravator and ask, with respect to that aggravator, does it exclude sufficiently? Am I wrong about that?
I don't disagree with what your statement is. I'm saying that we've got to start before that with the analysis of who is eligible to be charged with the death penalty. But it begins, Judge, with. So
her argument was that in order to figure out if Bryan Kohberger should be held, on death row, is to figure out who is eligible. So she wants the court to break down at the nuclear level or at the atomic level of everything. Who is eligible? How do they become eligible? When do they become eligible? Do you know how that's going to affect the case as far as time it would be to get this thing done? I mean, I guess what they're hoping for is that they can extend this 15 years before the trial even starts. And then he's got another 15, 20 years before he's executed. And that maybe perhaps by then he dies of old age. I'm not sure if maybe that's the the avenue here, I don't understand it. And it becomes very hypocritical towards the middle here when they start talking about speedy trial and start saying that, oh, woe is me. We didn't have the luxury of a speedy trial because it had to be within 6 months. And the thing is, they're the ones that are prolonging this trial at every step of the way. So it's ridiculous.
The definition of first degree murder. You start with the definition, which is very broad, of first degree murder.
Which is why the aggravators are required.
Right. And then you look at what happens within those aggravators. And we are arguing about the individual nature of those aggravators in other motions. So, these are different arguments.
But you in those other motions didn't rely upon Dr. Kohberger's article.
No, that's true, but it still comes to
he got her.
You still have to look at
This is sped up, so that was a pretty long pause.
But the aggravator is the eligibility.
It's part of the analysis.
I mean, everyone agrees the statute itself as to first degree murders that are eligible is without more unconstitutionally vague. That's why the court has U.S. Supreme Court then later approved statutory aggravators, including with judicial gloss, right? So then the question the court has said, the Supreme Court of Idaho has said, and the Supreme Court of Arizona has said is, and other courts, not whether when you look at all the aggravators together cumulatively, do those sufficiently narrow? The question is, when you look at an individual aggravator, does it exclude first degree murders from it? Does it narrow first degree murders? And you look at those each individually, not cumulatively. My understanding is that Professor Kohberger's analysis is that taken as a whole, these don't accomplish that. Is that accurate?
I would yield to her to testify to that, Judge.
I've read our law review article, and that's what she says.
That's the purpose of having her testify.
See, that's the whole thing. She's trying to argue that this lady has to explain to him what the article means in depth, and we have to go through this long portion because he can't possibly understand what it means without an expert to explain it to him. I don't think that's the best way to get on somebody's good side. That's just me thinking out loud.
I think that it comes in segments, and you have to begin with the definition, then you have to get to the aggravators, and then you have to look at what is the quantity of cases in Idaho that fall within both of those, pair it against what the result is for it being arbitrary and capricious. And when you're talking about our court, the Hidalgo case is from the United States Supreme Court, post-states what our court said in Hairston.
The other concern I have, I'll save that. I'm just now thinking about whether I need Dr. Kohberger. Why can't I rely on her law review article as a proffer of what her testimony would be?
Well, Judge, you are the trier of fact here, and it's important that you listen to, I believe, to make a reasoned decision, hear testimony, and hear that testimony be confronted and cross-examined. And that's what the United States Supreme Court said. I mean, if the state were to stand up here right now and say, hey, we concede, the statute's overbroad, the aggravators 11, everybody fits. What the United States Supreme Court has said is, we appreciate that concession, Arizona. It may genuinely exist, but we are a justice system where we want to hear that data talked about. We want to hear those issues confronted. We want to hear that debated. And so as a trial judge in this case, this is the appropriate time for you to hear that.
So the judge had already made his ruling that he wasn't going to allow their witness to testify. And this was like, oh gosh, I think it was like about 7 minutes ago in real time where we are in at this moment. And so let's fast forward another 8 minutes and see where there still are
justices of the Supreme Court.
Correct. It's still an invitation, and it's been accepted.
Let's go back a little bit.
So,
And that law review article was as of 2019?
yes, yeah, yes. And
Let's actually, I want to hear what that was. Let's go start right
I
here.
will indulge you for
you.
Oh, here, I wanted to hear this.
Shot to hell.
Like this is
Notice of death in that case.
This is the good part.
Now, there was a clear aggravator according to her for kidnapping, but again, when she lists whether or not a fuzzy aggravator applies, she writes utter disregard with a question mark. Again, Dr. Cover is relying, according to her article, on documents she was able to obtain from transcripts from the state appellate public defender's office. She did not indicate in her article that she had, I don't think she even argues that she had the same body of evidence that the prosecutor would have had in each of those cases, making those determinations. So what's essentially happening, and this kind of brings us full circle to the legal analysis issue with all of this, is that she's reviewing court records, making a legal determination that's different than the prosecutor who made that determination whether or not to file a notice of death, intent to seek the death penalty. This is not a reliable body of evidence upon which the court could even make that determination, if the court even wants to consider it as evidence, which in the state's position, it's really just a legal analysis where Professor Cover is just reaching a different legal conclusion based on court records and providing a statutory analysis. And so the state would just argue that her article is a sufficient proffer. We would ask the court to grant the state's motion and to disallow her from testifying today. Thank you, Your Honor.
Thank you. Rebuttal? Oh, actually, that was the rebuttal, wasn't it?
So he that was the rebuttal, and he tried to stop her, and she gets up.
If you'd let me talk,
I will indulge you.
Thank you.
My schedule is already shot to hell, but we'll indulge you.
Judge, we will be able to get through in one day. I think that the argument that the state just made feeds my point, which is they're drawing conclusions off of the raw data without talking to the expert. When an expert provides their spreadsheets and has notes without asking Professor Cover what a question mark means, what the exact records were, why she used.
What a question mark means? Jesus.
Those records, why the conclusions she drew were drawn. First of all, you don't have the exhibit because it has not been admitted. It's been provided to them because they were raising issues about wanting to see the data. Or if she's allowed to testify, she can talk about that.
This is the data that she used with respect to her law review article.
Correct. To draw her conclusions and do her study. And
that law review article was as of 2019?
Yes. Yeah. Yes. And so I think that the state just actually made the exact point that I'm trying to make to you. Thank you.
So since I have you, you brought up Hidalgo, and you talked about the Supreme Court doing this. My reading of Hidalgo is it sure was denied. A minority of justices issued their own statement in which they thought it would be important to gather additional information. The court itself did not. Am I correct about that?
One of the things about this judge here that it seems like he's familiar with what the defense is saying in the court, the hearings that they are bringing up and they're trying to utilize. When it came to Judge, it seemed like he was like, I gotta look into that. I gotta look into that. And I gotta see what this is. That's not the case with Judge Hippler.
Well, you're correct that cert was denied, but Hidalgo has been viewed across the United States as an invitation. It's not just Idaho that's done this, done a study. Other states have done the same at the invitation of the Supreme Court.
An invitation of 4 of 9 justices of the Supreme Court.
Correct. It's still an invitation, and it's been accepted as an invitation.
Thank you.
Oh, it was accepted as an invitation. All righty. So I think they're going to go to like a break or something like that here pretty soon. Let's see. Because I don't got anything written here for, I got it. 57 minutes was the next time I wanted to bring something up.
Is why I use the word observation. And had she testified, she would have explained.
Oh, so they're still talking about this lady after the fact. You can see his face. He's like, I'm tired of talking about this lady. We have denied her the ability to be an expert witness. We have her article that she was going to testify on. We can utilize that. He can read that. He doesn't have to go into all these things and actually speak with the lady. It's in there. And so we're still talking about that. And since since he's made his decision, it's been about 25 minutes and they're still whining and complaining that, can we please have her on? I mean, this is like, it reminds me of the time when they asked the judge. Remember, I brought this out before anybody else because all the other Kohberger haters, when they say that, he don't know anything, blah, blah, blah. I told you guys about that hearing that was going to be coming out where the defense mentioned that they were going to ask the judge to reconsider the grand jury stuff and sending it. And if they would also send it to the Supreme Court, and that was going to be on January 26th. And I put that about a month. I think it was still December when I dropped that piece of information. It didn't come out public until I think it was like 2 weeks until the day. So it was well into January. So anyways, it seems kind of similar here.
Her observations regarding that. But it is instructive to see that a study that was conducted in 1995 in Hairston has the same results in 2019, even if it's just an observation about geography. One of the things that the Supreme Court mentioned in its decision in Hairston is that they really wanted more information about the data that had been gathered and the reasons that there was a determination by Dr. Jensen regarding that and more analysis. But nonetheless, that was Dr. Jensen's conclusion and they are Professor Cover's observations.
You know, there was one spot, I must have missed it and passed it, but there was a part in the in here where Ann Taylor, you know, again, where's the confidence? Where is the confidence? You know, with Judge, he's an innocent man. We believe he's innocent. Judge Hippler, he sits an innocent man right now. I don't know if you guys had saw that part. I must have passed it and went on. But there was so many pieces of nuggets in this entire hearing that just destroys the defense's case completely against this. He's going to make a ruling. I highly expect that the DP is going to be allowed in if he's found to be convicted of the quadruple homicides. Let's continue here.
No, you
don't know what to say.
For those reasons, we are asking that you find, based on Professor Cover's study, taking it at face value with its conclusions and providing you with the data that we will look at and redact names.
If I go there, in other words, if I accept that there's an actual valid analysis to be done here, would you agree that I need to look at cases since 2019 as well?
So you talk a lot. What?
You know, Judge, the point of bringing in an expert today to talk about a study is that that's her expertise in gathering the information and putting it into a compilation. For you to engage in that,
and this is sped up, by the way. So those
I can't take her opinion because it's a legal conclusion. Looking at her data, which is 5 years old now, it seems to me that if I were to engage in that, I would have to look at the data as of today, and not as of 2019.
Yeah, I guess I'm not willing to concede that. And if it was something that needed to be undertaken, I'd like to have the opportunity to have Professor Cover testify about.
Here she goes again. She sounds like a used car salesman. At every point, you're like, hey, I need to think about, I understand. Let's go back inside. Let's go do this. Let's go do that. I understand. I'm not conceding. You're gonna buy your car today. She sounds like a used car salesman at this point. It's pathetic. I want to say thank you to 49er Girl with her $2 super chat. Happy Thanksgiving, everyone early. We also had Mountain Mama come in saying, I love my turkey family. Been a member for 20 months. And Justine Oki comes in with a $3 super sticker. Appreciate you guys. You guys are the best. You guys rock. I appreciate y'all. So yeah, these guys are still whining about this. They're still asking for like, hey, let's still let her talk. Let's let her talk. And even after he says he can't, they're still trying to sell that car.
About
She's
her
got no
time
opinion
frame.
about that.
Pardon?
She's got no opinion ultimately about that. She has some data that she collected that she thought was interesting and might require some additional study. I guess the point is that if I were to engage in that, it seems to me relevant, at least as to the state claim claim that the state equal protection, not state equal protection clause, but the equal protection as applied within Idaho geographically. Would need to look at that as of the time frame now.
Well, it could certainly be instructive, Judge, but if you're taking the data from Hairston, which was 1978 to 1995, and Professor's Covers from 2002 to 2019, the data, if it was analyzed, I'm quite certain would support both of their premises. I haven't analyzed it.
Of course she hasn't analyzed it.
Have that study done, but I think that there's enough guidance with all of those years of data to be able to draw the conclusion that it's arbitrary and capricious today, because the statutory language is still, the definition is still the definition. The statutory aggravators are still the statutory aggravators.
Man, she sounds like, what was that lady, Nicki Minaj? She's God compassionate and compassioned, or something like that. maybe that's where Nikki got her speech from. Must have been from Bryan Kohberger's defense team.
I have a case that indicates that an equal protection analysis can be applied on its face as opposed to as applied, because my understanding is an equal protection clause has to be analyzed as applied.
Yeah, I'm not able to, I can't right in this moment give you that case. I'd be happy to look into that and submit it as a supplemental authority.
You would agree if it is as applied, that would put your client's claim, at least as it relates to within the state of Idaho, as not being problematic.
Boom.
Given that he's from one of the smallest districts.
Boom.
Well, then I want to go back and talk to you, Judge, about
Of course, she wants to go back and talk about things that have already been decided an hour earlier in this trial, in this hearing. Thank you, Mountain Mama, for your $5 super sticker. We appreciate it. She's one of our mods. She's one of our members. This is a great support to the family here at DTS.
Premise in Hairston, which was pre the Capital Defense Fund, which also has created, in time, another dynamic of whether or not someone's charged with the death penalty and those costs at the time that he was charged. I mean, now it's different. So, yeah, I'm not going to concede that as applied, it just simply doesn't fit. I think that there are greater questions than that, but I don't have a case to point you to exactly. I don't think that has been.
Don't have a case to point it. So this is just all her opinion, all her thoughts and feelings bundled up, and hoping that because she thought about these things and this is how she feels, that everybody should bow down to her and her feelings and her thoughts, and that yeah, whatever.
It hasn't been raised in Idaho. We're making the first equal protection. In other district court cases in North Idaho, Mr. Logston has raised this issue, so I don't want to say you're the first, right? But it hasn't made it to the Idaho Supreme Court, to the appellate courts.
I just don't see how, as applied, you've provided the court any information where I could conclude that, because your client is from one of the geographic districts you claim.
Boom. I need to get one of those sound effects things that goes boom during these times, because this just dropping facts here on the defense team and just blowing them up. Look at Kohberger's face. He looks all concerned. That's the first time I've ever seen a facial expression. He's like, oh snap, I made the wrong choice again. The Speedy trial thing was a wrong choice by them waiving it. They're going to complain about that now that they shouldn't have, because their case is done. And they're not just talking about this. I'm talking about the fact that at the time they had 3 unknown DNAs. Those are no longer the case. The prosecution's already figured out who they are. It's been said in court a couple of months back. They talked about they had the phone cast stuff, and they had their dude, what's his name, Cy, and he came up and he said, hey, you know what, this can be fixable, you can do this, that, and the third. And not that I'm saying that he's right, because it doesn't seem like that. There's the Andrew Garrett stuff that's happened since. It just sounds like their entire argument is to extend the length of time that this is going to be. It's just, that's all it is. I mean, you can read right through it. I don't understand how people with half a brain can't see this.
Does not get its fair share of capital cases.
And we did not submit that argument in our brief.
Thank you, Art. Appreciate that. $1.99 super chat. Thank you. Appreciate you, Art. All right, let's fast forward this a little bit.
Thank you, Judge. I'll try and keep this brief. I think there are 2 problems, independent problems, with the theory that the defense is articulating here, and they both come from Idaho Supreme Court decisions. The first, as this court has noted, comes from Hairston, where the court said this just isn't how you do the analysis. You don't cumulate them and then do.
What's intellectually wrong with that analysis, though?
With cumulating and then.
I mean, I understand the legal cases may not be supportive of the defense's claim, but from an intellectual analysis, if the point is to make the death penalty less arbitrary,
correct.
Why wouldn't you look at the net or the cumulative as opposed to each individual compared on its own in isolation?
So, Your Honor, I think to answer that question, looking back to kind of how this was developed with the aggravating factors, the idea behind the aggravating factors is that you have to be able to show that this person is morally worthy of the death penalty. And so if you have individually analyzed every single factor and every single one you found constitutional, then it doesn't matter if in every case you could apply one of those factors, because that factor is a reason why that person is morally worthy of the death penalty. And so it's not an arbitrary and capricious system. It's not left to the whims of somebody. It's
But if you have so many aggravators that on the whole would essentially apply to any first degree murder, then isn't it just left essentially to the prosecutor as to which cases are not worthy to bring as a capital case?
So absolutely, the prosecutor would have a lot of discretion in that. I don't know that I agree with the characterization that it's left to the prosecutor, because of course the prosecutor has to prove that aggravating factor beyond a reasonable doubt.
Boom.
And if they can prove one of those aggravating factors beyond a reasonable doubt to the jury, and the jury finds that, then that person is now worthy of the death penalty. And again, when we instruct the jury, we don't instruct them to consider all of the aggravators in the aggregate. We tell them you have to consider them individually. We tell the state's required to present non-duplicative evidence for each aggravator that it's going to assert. It can't just throw out a blanket of aggravators. I think focusing on single aggravators is consistent from beginning to end of our entire system. And so I don't see a problem with that analysis that the Idaho Supreme Court said that that's not how you do this. And I would note, I think the court has mentioned this as well, it's not just the Idaho Supreme Court. There are many courts who have rejected this approach. The defense hasn't been able to point to a single court in any state, in any jurisdiction, that has used this cumulative approach to attack the death penalty or the statutory scheme of the death penalty in any state. So
that's massive. They have not pointed to a single court case in any county or state or district that shows what their argument. Nothing that validates their argument. Gosh, it is what it is. All righty, so let's kind of move forward a little bit. They're going to have like a break. Let's move past that. They come back and they talk a little bit. I have this scheduled at 1:50. And they talk about, okay, this is what I want to talk about here.
I don't know that I can necessarily draw just a distinction there. I think that they're, similar. Yeah.
Let me get what she was saying. Oh, look at her. She's just ready to get up and walk up there.
I think we are on now the motion to strike the individual statutory aggravators. I will give each side 25 minutes and you can address them in whatever proportion you like within that.
Okay, Judge, I will be covering heinous, atrocious, and cruel,
can't.
utter disregard.
That's
And then
funny.
I will do multi-murders, and Ms. Taylor will do future dangerous. So I'll basically do the next three. And given the time that you've asked, I'm assuming there will be less questions.
I will try to restrain my curiosity.
Right. I'm happy to engage with you.
I, as you know, I gave you some additional time, and that was why.
Right. Thank you. We are asking that the court strike the aggravator, especially heinous, atrocious, and cruel, manifesting extreme depravity. And I want to focus, I think I just want to start really focused on how this is different than Hall. We're aware that Hall, Arave versus Levitt, there's a lot of discussion about having addressed this aggravator before. We are framing it for you in our argument in a different way. And so what I want to show are the distinctions is that, Hall was a decision was issued in 2018. So was Hidalgo. So when Hall issued their decision, the arguments hadn't been framed in light of what we just argued about Hidalgo and that eligibility narrowing. And also, there was no equal protection argument, no argument regarding Article 2, Section 1 of the Idaho Constitution. One of the cruxes of this argument is that with the Idaho, but it still doesn't tell us anything about the culpability of the person who has been charged with the crime.
Well, isn't it more culpable to kill two people than one?
I think that consistently adhere to the primary canon of statutory construction, that where the language of the statute is unambiguous, the clear expressed intent of the legislature must be given effect, and there is no occasion for construction. And the courts have.
So I'll be honest, why I'm jumping around through here is I really, they're using some crazy big ass words. And, they're talking about aggressors and this and that. And I've never been an attorney. I'm not going to try to explain any of this. That would be ignorant of me to try to explain something that I just don't understand. I know there's a lot of people that go out there and do that. They're like, this don't make sense to me. This stuff that I have no idea of what I'm talking about doesn't make sense to me. Well, no, duh, it's because you don't know what you're talking about. That's why it don't make sense to you. I don't know what any of this means. So that's why I'm going to kind of go forward through it.
Have not taken that into consideration. So if the statute is unambiguous, then it should be given its direct meaning, which we quoted in our brief. And in fact, Texas is a good example of, it's a part of the definition of capital crime. And then the jury has to decide on the aggravator of propensity after that has been included as part of the narrowing in the Texas statute. So for those reasons, we'd ask that you strike the multiple aggravator as well.
Your Honor, we're asking the court to strike the aggravator of future dangerousness or propensity, whichever label we want to put on it, but it's found in subsection I of 1925-19, subsection 9. And I think when we're thinking about the constitutional way this is laid out to be protective of the Eighth Amendment, to have a true narrowing, and it can't be vague. We've been talking about that all day, so I won't go into that again. But with that in mind, I want to read the words of this aggravator for the court. That the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. That language does nothing to narrow. I'll skip right to the vague part of the argument. We're asking the court to consider three things in striking this aggravator. It isn't narrow, it's very vague, and it doesn't go to the culpability of the crime that's been charged, and if this happens, convicted of. Your Honor, this language, I think, has been acknowledged by our Idaho Supreme Court as meeting the gloss.
It's been acknowledged.
And I would say that what's required is that the statute, which Idaho doesn't have, has to provide the narrowing or the sentencing structure, and those things are legislative processes. And that hasn't happened. We have the gloss from the Supreme Court. The gloss that the Supreme Court has put on this, though, does not do anything but loop us back to the statutes that define murder and then exclude voluntary manslaughter. If truly we are to have an aggravator that selects out the worst of people who have been convicted of murder, this does not do that. The language in this aggravator is incredibly vague. When you think about really what is going to happen in front of a jury, they're going to get all this evidence that is supposed to be proven beyond a reasonable doubt.
So, Wonderful comes up with an interesting point. It says, crime was awful. I'm pretty sure the victims died as a result of cruel and unusual punishment. Just my opinion. This judge is way smarter than they are, in my opinion. I agree with what you're saying on all aspects there. But for me, I think that the question should be, why do this now? Now, I'm not an attorney. I'm not a lawyer. But I listened to some other attorneys and lawyers that have talked about this case. And one of the questions was, like, some of the arguments that they're doing now are typically these arguments that would be done, one sentence or after, or an appellate, trying to appeal things, because there's going to be 10 to 15 years of appeals and all those other things. And the question is, why try to get the death penalty taken out now? Well, right now, we don't know what the scene looks like. Right now, we don't know, what the, well, maybe not all of us know what the scene looks like. And maybe right now, most of us, a majority of us, don't know how horrible this thing really was and how it took place. We haven't seen those pictures. And then at the end of a hearing, there's always a victim impact statement. And I think that if you're wanting a jury to decide, because there are cases that they want the jury to decide this in grand jury before any of these things can happen, before they can hear the victims' families and do all these other things, or even see majority of the evidence, which is ridiculous. I mean, it makes no sense to do that. But as I mentioned, the whole purpose, in my opinion, why the defense has moved down to Boise in the first place was an attempt to get away from the victims' family members, forcing it to be more difficult for them to attend trial, So that way, the less that they are in, the jury's eyes, because, the jury's going to see the victim families going through some emotions throughout this case. When they start showing some of the pictures and some of the things, there's going to be some real emotions. They're going to hear that. They're going to see that. They're going to feel that. And obviously, if you're the defense, you're going to try to get in front of this as fast as possible. That way, whatever hope or chance that you have before somebody goes in there and sees the rest of the world sees the stuff that he did, then I get the argument at that point. But again, this is not typically, in my opinion, an argument that is typically done by a defense that truly believes that their man is innocent.
I trust the court will instruct them on that. But then they get this evidence that probably will make them believe that person's a future danger. The chance for a jury to misunderstand the call and the burden that needs to happen is really great. By the language alone.
So she basically said right now that maybe perhaps that the jury's not smart enough to understand the directions that they're going to be given. Like, do you see how arrogant and ridiculous that sounds? They haven't even met the jury. They haven't even picked them out. They haven't even had a selection yet. And now she's saying whoever they are, doesn't matter who they are, what they are, where their background comes from, what their education level is, what their profession is. They won't understand the directions, and we need to take that away from them, because they could make the wrong choice because they don't understand these, so basically trying to take the decision away from the, any decision. I mean, it's just the start of trying to take away the decision when it comes to being judged by your peers.
And Creech really doesn't do anything to help. The gloss that gets put on, the jury instruction that gets put on, doesn't help. That just says people.
Hall say that it was okay? I can't remember if they addressed that in Hall. I think
Hall did say it was okay.
So what am I to do about that?
You are to listen to that, allow me to make my record, which I am, but you were to say nobody else has talked to me about the real language in here when it says probably. That is confusing to a jury. This isn't a judge's call any longer. So
the argument here is that in the rule books about certain aspects, I guess a reason behind putting somebody else to death is that they will most likely or probably continue to commit crimes in a similar fashion. So she doesn't like the word probably, because that means that it's not a guarantee that they will. They can't guarantee everything in life. Like, I don't know what fantasy world that they're living in where they think, hey, you know what? I'm going to guarantee that Bryan Kohberger is never going to do anything again. And we should just let him free into society. This was an experiment of his. It was a one-off thing. We don't know he's going to do it again. So we shouldn't punish him in the manner in which, the crime that he did commit, allegedly. You see where I'm going? It's just ridiculous. And these arguments are just stupid.
But this is confusing to a jury to have those words in there. And the chance to find this aggravator, either based on one of the other aggravators, which we know cannot happen, or at a lesser burden because of the word probably, you're to find that is way too vague. And you should strike this aggravator because of that. Additionally, while we're talking about vague, there's a lot of potential for the jury to misuse mitigating factors and make them into future dangerousness aggravators. And
isn't that the truth, the possibility always in sentencing? I mean, one man's aggravator is another man's mitigator. And I think you pointed it out well in your brief of mental health, right? But isn't that the nature of individualized sentencing and
look at her face.
Consideration of those factors?
It's not confident like it was.
And I can't square in my mind how I am to do my ethical duty to my client and to abide by the guidelines.
Is the prosecutor? Oh, no, she has a pen in her mouth. I was like, is she laughing in the background too?
And then turn it over like I
maybe she is. That's why she's covering her mouth.
My client to the state's expert to grill him for however long. I mean, I have this duty. My client has the right to present this, but now I have to do all of this and give all of that information up so the state can use it in an aggravator that says, just tell me that the person will probably be dangerous in the future. That is just terrible, Judge. And for that reason alone, you should strike this aggravator.
Wow. Wow. She just wants to change the entire, every law, constitutional rule, freedom of speech, freedom of press, freedom of knowing what's going out there, freedom to protect yourself. Remember, they thought it was unfair to their client, for the families and the community, to have a vigil, because it would be harmful towards their client when it came down to, people thinking that he was guilty. I don't see where the dots connect there, or when the law enforcement decided to ask for help to find a 2013-ish Hyundai Elantra. I don't see how that is detrimental to their client. How asking for these things and these common things that are happening, and they just want to control you, and it's crazy. Wonderful asks, I wonder if he is planning to do a plea deal. What do you think? I don't know. So I think he's a little bit different than what we got in Richard Allen. This guy is probably the definition of a psychopath. Has no feelings, no remorse. And there's evidence of that. He wrote about it when he was younger in his Tappa Talk, that he struggled with remorse. He thought people were sacks of meat. He said that he felt like a sack of meat, and that he was an asshole to his dad, and this, that, and the third. All those things are written down, and he has no feelings. So this is pretty common. So, if somebody's going to commit a crime like this, you would expect it to be somebody who probably lacks remorse and these feelings and stuff. And look, there's very little emotion. I mean, right now he looks kind of worried, because I think he's realizing that his defense team isn't as good as he probably thought they were, and that this case is probably not going to go in his way. If they're losing these type of emotions now, he's probably putting in his head like, man, I'm probably going to lose all the other ones that were a long shot as well. So does he plead guilty? I mean, does he do a plea deal to not get the penalty? Maybe. But I think that he'd rather go up there and try to argue his way out before he would concede to something like that. I think that if that were to happen, that would probably be after maybe while there's deliberations on his guilt. But I would say that based on everything that I know, he better plead quick once the closing arguments are done, because he ain't going to have that long of an opportunity to do so. All right, let's continue this real quick, and then we'll jump forward a little bit.
The last comment I'll make is that future dangerousness doesn't go to the conduct, the culpability of the conduct that has happened. And that's really what these aggravators need to do, to narrow properly the scope of who's who. I can't tell you the number of times I've sat in court and listened to a prosecutor talk about at sentencing that my client or my client's acts are the worst they've ever seen. And that can't be true when you sit in court day after day after day and you hear that about person after person after person. This statute doesn't do anything to help a jury decide who's the worst of the worst. This aggravator absolutely has to be struck. It's a violation.
The fact that this callous SOB went into a house and took the lives of 4 people while they were sleeping and potentially even intoxicated, but when they can't even defend themselves, and he's armed with a 7-inch blade. Oh yeah. That's not reason to believe anything. That's not a reason. Jesus. I understand they have a job to do, as a defense attorney and stuff like this. But when it comes down to trying to, like I get it, you got to put your best case forward when it comes to these things. But this is out of pocket, in my opinion. Like all these things, it's just ridiculous. These are all things that aren't going to go anywhere. Allie Book says, other than the cell phone evidence, what kind of evidence do you think is in the house against him? In his house or his apartment? Well, it's been floating around. I may actually know this answer, may not. I'm not going to say. But I've said it, and I've hinted it enough to make you know whether or not I believe this or not. But they found him purchasing the knife. They found the means in which he purchased the knife. And they found other things that he had purchased, such as a jumpsuit, and that were purchased right before the murders. That mysteriously, the knife that he bought, the jumpsuit that he bought, can't be found. Right? You also have his DNA at the scene during the time while he self-admittedly said he was out and about. Right? That he said he was out and about. And at that time, apparently, according to him, while he was out and about, there was a mass murderer out there that just so happened to match his height and weight, that just so happened to have the same car as him, down to the front license plate, that just so happened to have Bryan Kohberger's DNA in his car. And just so happened to be able to transfer that DNA without transferring their own. There's quite a bit that when you look at this on a logical level, that would tell you that this man is guilty of sin. I mean, that's my opinion. I'm not a juror. I don't need to listen to the entire case to understand what's going on here. You know, it is what it is.
Violation of the 8th Amendment.
Thank you.
All right, so let's fast forward to this. The next thing I have is 202. Oh yeah, so I'm just skipping ahead from the what the prosecution's rebuttals are.
Won't follow the instructions. That can't be.
Oh, you know
so,
what? Let's back this up. This is the argument basically that I was saying, that you can't say basically that.
Your Honor, beginning with the heinous, atrocious, and cruel, this aggravator specifically has been upheld by the Idaho Supreme Court, and specifically the judicial gloss placed on this aggravator in Osborne.
Was
Now,
all a jury determination? You know,
I'm not sure on that, Your Honor, off the top of my head. I apologize.
I think it was, but I don't recall specifically. Notwithstanding the fact that I think that I'm the actual judge on the case now, I don't recall because that issue hasn't come up. But
Thank you, Your Honor. And I apologize.
Thank you, Robert P., for that $2 super
The
sticker.
defendant has raised this argument that in Verska, the Idaho Supreme Court's decision stating that the court would not rewrite or void an unambiguous statute is essentially the same thing as stating that the Idaho Supreme Court is saying that we can't put a gloss on a statute. But those two things are very different, because placing a gloss on a statute to ensure its constitutionality is not the same as rewriting or voiding a statute. If Verska is taken to that extreme, then courts can't interpret statutes at all. And that's not the holding of Verska. Verska simply stood for the proposition that the court was declining to rewrite or void a statute. And of course, the Idaho Supreme Court has never rewritten the heinous, atrocious, and cruel aggravator or the utter disregard aggravator or any of these aggravators. They've simply placed a judicial clause. As to the future dangerousness and propensity one, which was the most recently addressed, that too has been upheld by the Idaho Supreme Court in State versus Creech. The propriety of considering future dangerousness has been upheld by the United States Supreme Court in Jurek versus Texas.
Check
In
it
the
out. She's eating her nails in the
propensity argument,
back.
future
She's so
dangerous
nervous.
argument,
Look, check out next to Bryan Kohberger's right side there. The not Ann Taylor, but the other one. I apologize. I'm bad with names, guys. You guys know how bad I'm with names. And so I'll probably call her Pam in a little bit. Well, anyways, you have this attorney here just chewing on her nails like crazy. Like, man, they're just killing everything I just said. Look at that.
The defendant is essentially asking this court to start with a proposition that a jury is not going to be able to follow the court's instructions. And of course, we can't start with that proposition because juries are presumed under Idaho law to follow the instructions that they're given. And that is another issue. That issue is also true in the defense's multiple victims argument. Their argument with multiple victims really doesn't cite to any case law. It's simply based on the fact that they're assuming.
Is that Tommy right there in the green? If you know, you know. I wouldn't be surprised. He is sitting behind Kohberger. But I could, no, that's my vision. My bad.
That a jury is unable to.
For a moment there, it's just so blurry. And the screen is just so small. For a second there, I thought from a certain distance, it looked like somebody I knew.
Distinguish between propensity and multiple victims. And again, the court is being asked to start with the presumption that a jury won't be able to follow the law. And that's contrary to the state of the law. We can't presume that because juries are presumed to follow the law. Additionally, we also can't start with the presumption that the state is going to just put on the same evidence for all these aggravators. The court should also assume that the state will put on independent bases for each of these aggravators during the penalty phase. That's our legal obligation, and the jury will be instructed.
I just saw the long
They'll
hair.
be instructed that they can't double weigh or double count. That's very clear in the case law. The state would just ask that the court decline to presume that
But
the
I can't
state
see that well from here.
will present the evidence in a way that's contrary to law and that the jurors then won't follow the instructions. That can't be, Your Honor. So the state would ask the court to deny the defendant's motion as to these aggravators. All of these aggravators have been upheld, specifically the hack along with disregard and future dangerousness. There is case law directly on point that is binding on this court. We would ask the court to deny the motion.
Thank you.
So I just let her talk about the stuff that I mentioned before. Oh, here comes.
Judge, to answer your question about Hall, Hall was originally sentenced by a judge, and then the sentencing was retried, and Mr. Chastain and Ms. Christensen handled that case.
My memory came back to me between.
Lights are too bright for that.
I want to point out that Verska says, if it's socially or economically unsound, the power to correct is the legislature's.
Yeah. No, I saw that now. I had to get real close. I don't know if you guys, because I just saw from a moment, and I was like, "Whoa, I think I know that guy," but no, it's not.
Not the judiciary's. If it needs fixed with construction, as we argue that it does, it must be stricken. And I want to address the question that you asked about why not wait until the evidence comes in and I can strike the aggravator at that time. It goes to the point of why we are arguing all of these right now. There's a huge difference between picking a death qualified jury and a non-capital qualified jury.
Well, but that just went to my point of your argument presumes I would strike all of them. If, for example, I were just looking at multiple murders versus propensity, and those two so overlap that you can't have both. You could still have one, or you could have both. But if there's not evidence.
So I know somebody said that Bryan Kohberger looks a little small. I think that you can see the chairs around him. They're all the way up. And his chair's probably all the way down, which is what's making him appear to be kind of small. But I think it's just the angle of the dangle and the view that you got here. And I think it's his chair.
Independent of one, then you would strike the one.
So you're correct that we are asking you to strike all of them so that we don't have to pick a death qualified jury, because death qualified juries are highly likely to convict in the guilt innocence phase. So we are very, very concerned about that and the fact that that is so different in a death penalty case. But to the extent that you might strike some and save one, for example, the aggravator, there's a vast difference in what happens in front of the jury in the selection phase with that aggravator versus the others that we are asking you to strike. Thank you.
Thank you.
Let's move forward because it gets interesting. Let's go a little bit. Now what they're trying to, they're going to come across with the speedy trial stuff. So up to this point, they've been arguing about, they want to go and define what death penalty means and go into the go into who is eligible and define what eligibility means, like to the bare basic surface, and start from that process in this case. But now they're also going to argue that it's not fair that this case is taking too long.
For aggravating evidence because it's relevant to the aggravating factor. And just to be frank, I can't even come up with a good example of what the state would put on in this case that would qualify as not relevant.
There's like, what did they say? Like a pool of like 18,000 jurors that they're going to pull in. I'm sure they'll be able to find 18 or 1,800. Could have been one of the two. I'm sure they'll find 18 people that are okay with it. It's Idaho.
Into an aggravating circumstance.
Not saying that it's bad or good or anything, but I relatively think that Idaho is probably a little bit more on the side of conservatism type of things. Like the no DP type of stuff is more like a liberal type of movement.
But
don't want to get political though. Not tonight.
I guess my point is
I've had too much fun already.
It's going to be an issue given that we will, of course, comply with discovery. We will provide everything that they'll know what we're going to say before we say it. And if there's an issue, we can raise it at that time and discuss, is this actually relevant to a statutory aggravator or not? And if not, does it
swap 8 and 9? Just because I could see
any objections that they want beforehand, I don't know that that this will be an issue in the case. Unless there are any other questions, we would ask that you deny the motion. Thank you, Your Honor.
Your Honor, I would start by saying I thought I heard the state get really close to saying they're not planning to produce any non-statutory aggravators or non-statutory aggravating evidence, whichever way you want to talk about that, which might be really good. It might save the court having to make the decision if they get all the way there. I would say, though, there's not a statutory list of non-statutory aggravators, but in Hall, it talked about, that decision talked about things in a person's background, if they had a prior criminal history, things about their character. And a prior criminal history, that's fairly definitive. Either you have one or you don't, right? But things about a person's background, that's where it gets really questionable. Are we talking about people's opinions, people that maybe would have an axe to bear with the...
So I think what she's trying to bring up now is that, you know, they're going to look at his history. So this is a big, huge thing that's going to be coming in, and that they feel there's going to be people that have an axe to bear against him. Probably, they're probably talking about John Snyder, the professor that had an argument with him, the staff that fired him, and all these other people that had a negative impact with him. But it sounds like there's going to be quite a few people that are going to be talking about his background and his past and why he is not such a great guy, right? So it sounds like they're really preparing and trying to get ahead of that right here and talk about how, you know, those things shouldn't be considered when it comes to the death penalty, and a decision is, you know, how other people felt about the man, because there could be extraordinary reasons as to why they believe or feel about this person. Well, that's why you go and you get your own character witnesses, and you combat with, you know, the character witnesses that they bring, that the prosecution brings up. Now, if you're arguing it so bad right now, and at this point you haven't even gotten to trial, probably means you're having a tough time finding people that that aren't up his, you know what, right now, because from afar, some people that actually knew who he was, you know, before the murders. You won't probably find a lot of people that are sticking up for him.
The person that they're talking about. So I think that when you consider what Hall talked about as a non-statutory aggravator, it becomes really important that the state have the burden of proof of beyond a reasonable doubt for those. I would just close by saying that Gardner versus Florida talked about why we have notice and that reliability matters. But it's the same thing on this kind of information, this kind of evidence, these kind of non-statutory aggravators that get produced. It has to be reliable, and the court has to be able to rely on what a jury comes up with. And Mr. Kohberger has a right to have information come in fairly, to have notice of that information, and for the state to carry the burden. And they need to carry the burden if they want to present non-statutory aggravating evidence. Thank you.
Tumbleweed comes in with a $19.99 donation saying, thanks, Daniel. Thank you, Tumbleweed. We appreciate your support and donation. Thank you so much. You're amazing. Appreciate all of the viewers. Hit that like button, by the way. We have a 500 likes goal. Let's get that going before the end of the show. But the replay crew, you can still hit the like button too. All right, so this is going to be fast forward to where I wanted to get. So what they're going to do is they're going to be talking about, you know what, I'll let you hear, because they bring up this Logston guy. And
I'm going to swap 8 and 9, just because I could see 8 potentially going a little bit longer than 9. And so, well.
Your Honor,
Yeah.
can I help in that?
Yeah.
If the court takes the first part of 9, the speedy trial issue, that's the one I'm handling. And I think we've got Jay that's ready on the rest of them. We can cover it, but he's really close.
So he's not here. All right, well, let's start then with 8 contemporary.
They could have done it, but they really want him to do it. Man, the judge's response to everything he said is amazing.
Standards of decency.
That's the one that Mr. Logston
Oh, he is.
would be here. I've got Speedy.
Do you have, who has trifurcation?
Jay is the one that's the most prepared on trifurcation.
So you've got Speedy. Let's start with that then.
I can do that. Thank you, Judge. Your Honor, we're asking the court to strike the death penalty in this case based on a conflict of constitutional rights and Mr. Kohberger having to face the choice between holding on to one constitutional right at the expense of another. And that's what's happened here. He has had to choose between his two constitutional rights, and those were effective assistance of counsel or speedy trial. Mr. Logston wrote the brief on this, and he did a really good job with the history and why we should look at Idaho's speedy trial, constitutional guarantees of speedy trial, in the same time frame that the statute 1935-01 says. I'm not going to go into all of that again, because really this is about the choice of picking between constitutional rights.
It seems to not to go into history that your argument essentially asks the court to equate what the pre-constitutional statutory standards were as then constitutional standards. And I think the court has said that that's not the case. Am I wrong about that?
I'm not sure I'm following what the court's asking me. I'm sorry.
It seems that you're asking the court to equate what the statute said about speedy rights for the Constitution, Idaho Constitution provided for it, and treat that as the constitutional standard and grafting it into the constitutional standard.
I would say that it's there to provide guidance, because there was that the statute we have now is after the Constitution.
So the statute they have is only there for guidance. Yeah. When was that? When has that ever worked for you guys when you get pulled over for a police officer and you're speeding and you go, hey, speed limit's more of a suggestion. It's just guidance. It doesn't matter what other statutes say. It's, it's more like opinion. Good luck trying that if you ever try to get into a speeding ticket, much less something like this.
The territorial statutes were before we had the Constitution. And when Idaho wrote its Constitution and said, we guarantee defendants a right to a speedy trial, there was that already in mind.
So I just don't understand the argument though. Like they bring up, and I'll bring it up here in a sec. We got Stephen coming with a $10 super chat. Thank you, Stephen. We appreciate you, my man. So let me get to that part real quick, because then what they're talking about that next is they're trying to compare today's situation with COVID.
Good cause basis. I mean, capital cases at the time the Constitution was adopted were tried within 6 months, right? The standards of how to try those cases were obviously different, and as more contemporary thoughts about that have arisen, it's become the standard that they require more. And so why wouldn't Speedy be flexible to accommodate that?
Well, I don't know why it would or why it wouldn't, but that's not been what's happened. We don't have a separate criminal rule that says that. We don't have a separate statute that says that. We would bend the Idaho Constitution until it breaks to make it say that.
Yeah, we know all about you breaking laws and rules and all this other stuff to try to make your client. It's not something we're not familiar with.
I'll give you kind of an example. During the time of COVID, when the Supreme Court told the speedy trial rights, it did that based on a national emergency. Court orders were issued. I am not saying whether I agree or disagree with that, but that's something that happened. And I think one of the cases the state cited in its response brief, State versus Ish, I think that particular case had 422 days of time between when the remittitor was issued and when the case went to trial. And that person asserted their speedy trial rights that whole time.
So she's trying to say that because it happened in COVID, when there was nobody interacting with people, they had to figure things out, and they extended the jury, the speedy trial rules. I think it was like 400 days or something like that. The only persons that have extended this as long as it is the defense. So they're arguing on themselves. That's like somebody saying, like, man, I really hate being large, but I can't stop eating 2 pizzas a day. I should be able to eat 2 pizzas a day and also, have a 6-pack, and not talking about beers or soda. It's stupid.
That happened during COVID when the court had its emergency orders during that whole time.
Even
So
even
I think
Hitler's like, oh, come
to say, well,
on.
it's a capital case and they're a lot different than they used to be, and they are, and they're a lot of work and they take a lot of time and investment. They do. But there's nothing that's been changed in our Constitution, in a court rule, in a statute to say if it's a capital case, speedy trial, really, you just don't have that right. A person facing the death penalty just doesn't have that right. All of those rights exist. They all exist right now. And Mr. Kohberger had to choose between those rights. And I think the court can and should strike the death penalty in this case based on the record.
That would
here.
result in the death penalty being struck in every case.
Boom.
Your Honor,
Oh, so that's what she wants to do. Look at her hands. Hey, that's what I'm here for. I want to make precedent. I want to make something huge. I want to be the person that brings this up, so that way there's no more death penalty. I'll be paraded. They'll carry me down New York Times, and they'll throw parades. And come on now, come on. Even look at how relaxed he is. Hitler's just like, come on now. Like his facial expressions are amazing.
if that's the way it is, because our clients collectively in the state of Idaho, when you have a capital client, if that's the case, then that's the case. I mean, we have been doing
The Constitution is flexible enough for the Supreme Court to itself say, well, we can pause that right, and we can expand that right based upon the circumstances, i.e. COVID. Why can't it expand the time that speedy is measured by constitutionally, given that evolving standards have required more time to present a capital case and measure it against that?
I would say that I don't know whether they can or they can't, but they have not. And that's the critical area. I would say the Supreme Court probably would believe it could do that, but it has not done it. And I would say they would believe that they could because they did so during COVID. But that hasn't happened. That has not happened.
Well, that's why you can't do it now.
The Supreme Court would likely say, well, as opposed to interpreting the constitutional right more broadly to apply over the more flexible, given how the defense of capital cases have evolved, they would be more likely to say, well, we're just going to not have any capital cases, period.
I don't know if they'd say that or not.
Well, that's what
But
you're asking me to say.
I'm asking you to say that. I'm asking you to do
My job as
what
a district judge, if there's not an issue that has been decided by the court, to determine how that court would decide things.
Well, I think you can consider what Judge Boyce did in the Vallow case, and that had to do with discovery that counsel didn't have enough time to review and to prepare for, and it would have disadvantaged the client. And so Judge Boyce in that case struck the death penalty.
That was as a result of the state having failed to provide the information, violating its court order. And then the remedies were, well, do we push trial back or not? And the choice that Judge Boyce gave the defendant was, well, we can go to trial, but I'll remove the death penalty because a lot of the discovery related to that. Or we can continue the trial for you to review that. So you can either go to trial with the death penalty, without the death penalty now, or you can expand it with the death penalty. One defendant chose one and the other defendant chose the other. In this case, the decision to waive speedy is not as a result of, as I understand it, a violation of a court order by the state.
It was.
You know, let's go back to that. Let's go back in time to when Bryan Kohberger decided to waive his speedy trial. Let's see. Let's go back to that. Just to refresh our memories. So this is back. Was he waiving it because he's being forced? Let's find out. So they're signing their little ordeal, their paper, because they don't want to.
So, Mr. Kohberger, did you read this over? Yes. Okay. What I'm talking about is the written waiver of speedy trial. Yes. Did you understand the terms here? Yes. Which we've already talked about. Yes. And you agree with the signing the form waiver of speedy trial, Ms. Taylor?
I do not.
Okay, so Mr. Kohberger, do you want me to accept your waiver?
Yes, I do.
Okay, and you understand that if I accept your waiver, you're giving up your constitutional right under the United States Constitution and the Idaho Constitution on a constitutional right of speedy trial?
I understand.
Do you understand that if I accept your waiver, you're also giving up your statutory, your Idaho statutory right to a speedy trial?
Yes.
And that is within 6 months of your waiver?
Yes.
And you agree with the tender of the waiver, Ms. Taylor? Kohberger, do you want me to accept the waiver?
I do.
Based on our discussion, your waiver of these rights expressly in court and also in signing this waiver of speedy trial. Also, you are entering these waivers on advice of counsel. I will accept your waiver of speedy trial. I find that your waivers are knowing.
That's enough. There's so much clicking in the background. It's, but maybe I didn't go too far, or maybe I went a little bit too far. But there was a point where he's like, "Are you sure you want to do this?" And he was like, "Absolutely." And now here we are. Here we are. Just a little bit later, more evidence and more stuff pops up. Just like when he was so, he was so convicted on, or maybe not convicted. He was so convinced that he was going to be able to show his, be exonerated. He was anticipating this. Man, he sure has stalled quite a bit for somebody that was ready to go.
As a result of a court order. And when we waived speedy, we advised the court and counsel that this motion this day was coming. We don't think it's appropriate to force somebody to choose between competing constitutional rights. Lori Vallow had not ever waived speedy trial. And so she had the choice to waive speedy or not face the death penalty. And we think that since we were forced to choose between rights, those should be reinstated and the court should strike the death penalty.
Thank you.
Thank you, Your Honor. So not only can the Idaho Supreme Court do that, it's already done it. The Idaho Supreme Court has said that we interpret Idaho's Constitution for speedy trial the same way that the federal Constitution is interpreted under Barker. There's one exception that has no application here. And so it's an individualized test based on 4 factors, and you're really looking at kind of the overall reasonableness of the delay. I would direct the court specifically to the Langford case that just came out last year. The Idaho Supreme Court walked through the difference between the 2 constitutions, explained how they operate, and then found specifically in that case that they charted out how many delays there were, what the delay was for, who caused the delay, and then was it reasonable or not. And
who caused the delay? This is exactly my point. Who caused the delay? It wasn't the prosecution side. It's not been them since this entire time. In fact, even if they said, "All right, Bryan Kohberger, once you're 100% ready to rock and roll, we'll go at your leisure right away. 1 week later, we'll set it up. We'll get everybody in. We'll figure it out. We'll have the stage. We'll use the judges from The Voice, and we'll get you everything that you want." And does it make a difference? Like it still wouldn't have happened. It still wouldn't have happened yet. He would still be in this situation right now, crying about the death penalty.
And they found, they said, in sum, most of the delays here were precipitated by Langford's own actions. In the case of the last and longest continuance, the delay was reasonably necessary to allow new prosecutors and new defense counsel time to prepare for trial. So they found that's a reasonable, under the Constitution, that is a reasonable delay. So there is no choice here. You don't have to choose between speedy trial or effective assistance of counsel. You can have both. I think what the defense is saying is they've lost their statutory right to 6 months, which they do lose if they take an action to delay the trial at all. But that's not a constitutional problem that they have to give that up if they want to maintain their constitutional right to effective assistance of counsel. Now, in this case,
Well, and that was my point in perhaps not well stated, is that it seems what this defense is trying to do, and perhaps you can comment on whether I'm seeing this correctly, is to engraft what was the territorial law, which is that a case had to go to trial within the, at that time, courts were held in sessions, calendar sessions, right? I think there were 2 sessions a year or something like that. That was the Speedy right. And then we had the Constitution that doesn't, necessarily give us such a fixed time frame. But the argument is, well, because that was the territorial law at the time, therefore that's the constitutional right. And it is engrafting that statutory construct to mean the constitutional right.
Potentially, Your Honor, though I'm not sure that's exactly, because my understanding of the pre-Constitution statute was that it was based on kind of the circuits and when they came, and we don't do that anymore. And so that time frame just doesn't make sense today. You wouldn't be able to just engraft that in the Constitution and apply it today. Because
my point is, that's I think what the defense is arguing essentially.
Yeah. Yes, Your Honor, but the statutory right they're pointing to comes from the new statute that was passed in 1980 that gives the 6-month time period, and regardless of whether they want
argument that the 6-month is functionally equivalent of the twice a year circuit.
If that is the argument, I don't think that it gets past the Idaho Supreme Court has said no, it's not. So, under the Idaho Constitution, we use the Barker test. The crux of the matter here is that the defendant didn't have to waive his constitutional right to a speedy trial. He did. He did so under advice. He did so in writing. He did so knowingly, but he didn't have to. The trial could have been continued, even at his own request, without him waiving that right. He waives it statutorily by moving for a continuance or to ask for more time to prepare, but he does not waive it constitutionally. If he did, then most of this Langford analysis would have been completely unnecessary. But instead, at the end of the day, when you do finally get to trial, the reviewing court looks back and breaks out segments of time and says, whose fault was that delay? And as the court said in Langford, many of the delays were because of Langford, and so they don't count against the state. But the court easily could have said, well, he asked for a delay, so his constitutional right was waived. They didn't, because that's not how it operates. So the real problem here, I think that the defense is grasping with, is that they didn't need to waive his constitutional right, but they did. So, there's not much the state can say other than that wasn't required. The Constitution not only can be flexible, the Idaho Supreme Court has held that it is in fact flexible. And one of the reasonable, a proper reason for delay is to prepare for trial. And that means this is not a choice that has to be made by any defendant. It didn't have to be made by this defendant, but he chose to. Unless there are any further questions. Thanks.
Just briefly, Judge, we're not trying to graft in a time into the Idaho Constitution. We're looking at the word, the guarantee for a speedy trial, and trying to figure out what the word speedy means. And so,
Doesn't speedy mean the Barker test?
Well, at the time the Constitution was written, I don't think it did.
But isn't that what the Supreme Court has said it means?
Boom.
I think our Supreme Court does agree that it's the Barker
Again,
test.
I think I probably can dispose of a number of motions by simply saying that the defense asks me to do X. Doing X would violate the binding precedent of the court.
Boom.
I think if I was here saying dismiss the case based on a speedy trial violation, I think that's exactly what the court would do. This is a little bit different. We're asking for the court to set the case back to the point where we had to choose between constitutional rights and to strike the death penalty.
So now they want to go back to that point where he can make the decision of, does he have 6 more months from, I guess, today, which would actually bring the trial into May, or does he have the right to waive that? And let's just say they go all the way back into, like, they decide to start it over there. And even in that point, he decides to waive it again. What are we even talking about? Because they don't want to go in May. They don't want to go in June. This is scheduled for August. Unless you're arguing that you want to do it early, which they weren't able to argue that before. They didn't. They were the ones that said, hey, September looks more reasonable. They're arguing with themselves. This sounds nonsense. It's just nonsense.
In our case, this is the last point I'll make. In
Please.
Our case, we signed a waiver of speedy trial, and it was a form, I believe, that was generated by the court. It was signed on August 23rd, 2023. Mr. Kohberger signed it, and I assigned, with the parentheses, attorney for the defendant. And in that form, and remember, our scheduling order said you have to do it by this day, or you don't get a continuance, you just go into trial. We gave up the right to, under the United States Constitution and the Idaho Constitution. And I have a printed copy, but I know the court probably has the entire court file.
Yeah, they probably do.
All right. That, along with the other motions that will be taken under advisement. Let's take a lunch break. It's 5 to 12.
Now let's fast forward this.
Adjourn at 1 o'clock. Thank you.
So as you can see, Jay is back, so he'll be there when they come back. And here comes the hero of the day. Where is it at? 357. Just find the spiral.
Besides the prosecutor, which is what we have with grand juries and preliminary hearings, et cetera. And so we still believe that the argument here is one that is one that can be passed on by this court and that hasn't necessarily been ruled on by these other cases that we also think should be overturned. Thank you, Judge.
Thank you.
I believe I have all the remaining arguments,
All right,
so
well,
whichever the court would like
let's
to.
finish up topic 9 with your contention that the death penalty should be struck because it violates international law.
The death penalty should be struck because it defines our national law. That's their argument right now.
Thank you, Your Honor. So that motion is largely premised on the International Convent of, I'm gonna have to pull it up because it's the ICCPR.
Oh no, I don't know what I'm doing. What's going on? Pressure. The lights are too bright.
International Covenant on Civil and Political Rights. And so essentially the argument comes down to this. We have signed and ratified a treaty that would put, we think, additional requirements on what we would do if we're going to have a death penalty in this country, and obviously we have one. One of those is a requirement that we make sure that we're not arbitrarily killing people. And the other one is that people are not being essentially tortured.
My understanding is when the time that that convention was ratified with the understanding that to the extent that it is agreeing to anything, it is agreeing to afford the Eighth Amendment protections.
So yeah, he mentions international law, national law. There's a bunch of different things that they're going to be, that Mr. Loxton's going to be bringing up. I just want to get to one specific point, and then I'm gonna let you guys know what Judge Hippler has to think, or what he thinks about the entire thing.
That's correct, Judge. And I think to some extent, what we're arguing is the Eighth Amendment and the ICCPR work together, and that we can look at these international obligations and the Eighth Amendment and say that they essentially are the same thing. That's why we talk about.
Well, I think you're looking at it from two different prisms. I think what the state is saying, to the extent that this covenant applies, which is questioned about whether it's self-executing and all the rest, it only governs to the extent that the Eighth Amendment, apart from that, would.
Let's move it here. So let's go to where Judge Hippler kind of characterizes everything that Loxton has said since he's come in.
As flat as you would expect it to fall before our Supreme Court.
Let's go here. Right here.
Big enough to drive a Mack truck through. And so just about every murder could be charged and have the death penalty attached to it. And so that doesn't require the narrowing that we've said we're going to provide. And it certainly doesn't live up to what the international community would expect from us.
The international community, yeah. Like this is
I understand the argument.
Well,
I'll be frank, it's falling about as flat as you would expect it to fall before.
Let's go back, because I'm going to put this in normal time so we can hear this right.
The death penalty would be struck if it was done properly. Our argument is that the way that Idaho has its scheme set up, there are far too many statutory aggravators, and some of them are just big enough to drive a Mack truck through. And so just about every murder could be charged and have the death penalty attached to it. And so that doesn't.
Maybe it should
require the narrowing that we've said we're going to provide. And it certainly doesn't live up to what the international community would expect from us.
Yeah, I understand the argument.
Well,
I'll be frank, it's falling about as flat as you would expect it to fall before our Supreme Court or the Supreme Court of the United States.
Boom.
All right. It's an argument and it must be made. So
you need to make a record.
Thank you, Judge.
I'm sure you need to make a record. All right, so let's go. Let's hear what the rebuttal is real quick, because it's I think it's a good one. Let's go. Right here.
Thank you, Judge.
That's the same spot. But let's speed it up. Let's speed it up a little bit.
Thank you, Your Honor. While Roper may have looked at some international law, I think the Idaho Supreme Court has really narrowed that window. First in Abdullah, they said, therefore, absent some legislative or executive action, the determination by this court that Idaho's death penalty statute is unconstitutional based on evolving standards of decency and public opinion is unsupported. So they're really looking at that. And fast forward 5 years in that Hairston decision, 2020, the Idaho Supreme Court reaffirmed that view and then also said, quote, we continue to subscribe to the view of legislative bodies as the basis for determining a national consensus. And so, and the reason for that, they explain in Abdullah, is that courts just aren't good at taking a temperature of public opinion and what represents society's views. Now, looking at the states that have capital punishment, according to the resources both sides have cited, there's 27 states that still have it on the books. That's a majority. They've pointed out that there's gubernatorial moratoriums in 6 of those, which is true. But that means worst case scenario, there's 21 states that still have the death penalty on the books and can use it. And what the Idaho Supreme Court said in Hairston is that we're looking for a national consensus. And we're nowhere near a national consensus that the death penalty is somehow immoral or improper or indecent. I would also just note, it's not enough if what you're trying to show is a national consensus, it is not enough to just point to the fact that a state doesn't have the death penalty. You would have to show that the state removed the death penalty because that state believed that it was immoral and improper. So for example, if a fiscally conservative legislature just decides they don't want to fund the death penalty, but they have no moral objection to it, that's not evidence that there's some societal standard that would.
What do you take of evidence from a state who is not enforcing the penalty?
Listen to this.
Because, for example, an executive of that state is morally opposed to it and has the power to preclude it from being applied. Should that be considered?
So the Idaho Supreme Court did mention executive action, although in Hairston, they seem to say that the better picture is painted by legislative bodies. And I think part of the reason for that is because the executive, it can just depend on the administration that's in power at that moment. A perfect example of that is the United States. The death penalty is on the books. It's currently not being applied, but shortly before the current administration, it was. And I think it's safe to assume that it will be again here shortly.
So what he just said was that currently, federally, the death penalty is on the books. It's just not applied. It was prior to this current administration, which is going to be the next administration, which is why he's saying that that's going to change anyways. So another way that Trump saved the day, I guess. I'm sure there's a bunch of liberals that are on the Kohberger side going, now Trump ruined this. Crazy.
The other thing you have to look at is, why is the executive doing this? For example, the defense cites that Tennessee has currently a moratorium. True, but the governor did that because he said we need to take time to fix the execution protocol.
All right, let's go forward a little bit. So let's listen to Jay Loxton come back on.
Thank you, Your Honor.
Just briefly.
They almost hit Kohberger in his Frankenstein head.
I would caution the court trying to figure out why it is that a particular state either dropped the death penalty or imposed a gubernatorial moratorium. I mean, I think that these things are complicated. That looks an awful lot like trying to figure out from legislative history why something occurred. Half the time, what you see in the questions doesn't necessarily tell you what the legislature had in mind when they finally voted. And so I think the first step, as the United States Supreme Court has set it out, is just to look at the numbers. And then after that, the courts can consider other things.
Or 2021, if you take into account moratoriums. How, I mean, certainly more than a third of the states, how does that represent a consensus?
Boom.
I would argue that the consensus can also come from trajectory. So the fact that so many states dropped the death penalty within the last 10 years, and that appears to be the direction that things are going, is something that the court can take into account. I also note a lot of these states that have death rows and don't have a moratorium still aren't actually executing anyone. And so the actual number of executions in the states that are actually executing anybody is even than that. I think it's something like 13 jurisdictions that are actually doing executions. So anyway, for those reasons, Your Honor, we are asking that you strike the death penalty.
Thank you. All right. think that leaves us with your motion to trifurcate the proceedings and to apply the rules of evidence in the penalty phase.
Right. So, Your Honor, I tried a case via the trifurcated method. It went smoothly, and we moved this court to do the same thing.
Let's go to the rebuttal, because it kind of, the defense kind of talks around things, and they try to use some smoke and mirrors and big words to say, hey, I'm smart, I know what I'm talking about, even though I'm not saying anything. And the prosecution just comes in there and just smacks them down, says what they're trying to mean and how it's stupid.
Consider doing this as a trifurcated trial if it gets there. Thank you.
And Your Honor, to briefly address the point about the confrontation clause and the rules of evidence. Defendant has fairly acknowledged in his brief that the Idaho appellate courts have issued binding precedent that's contrary to their argument today. The state's not going to belabor that point. I think the case law is clear, and the state briefed that. As to trifurcation, the defense has yet to lay out what exactly this process would look like. And what I mean by that is, at what point it appears, although the defense has not explicitly stated this, that they would encourage this court to adopt a procedure where the state puts on all of its aggravating evidence for all of these statutory factors, and the jury then goes to deliberate on these factors without hearing any of the mitigating evidence. Now, this is very concerning, and particularly, the state briefed this. You take the propensity aggravator, where the jury is tasked with determining whether or not the defendant's going to pose a continuing risk, to send them back to deliberate without allowing them to hear evidence and mitigation. That's very concerning to the state about what that might do to, for example, the appellate record. And I think that post-conviction proceeding in the Renfro case really highlights the concerns with this procedure that they're asking the court to adopt. As to the assertion that this is simply too confusing to the jurors, the court will instruct the jury on what the law is. And as we've argued on these other motions, the court can't just start with the assumption that jurors aren't going to follow the law, that it's simply too concerning or too confusing for the jurors. The jurors will receive instructions. They are presumed to follow those instructions as a matter of law, and the court should assume that these jurors will do as they're instructed. And unless the court has any questions for me, that's all I have. Thank you, Your Honor.
They didn't have to drop much. Let's go to, so they're about to end it, right? And I want to show this real quick.
It's going to make it simpler for them to understand, okay, you've now found this person guilty. Now you're going to be determining whether or not one of these statutory factors exists. This is what they are. This is how they're defined. You have to find this beyond a reasonable doubt. The state's going to do an opening statement and a closing. They'll put on evidence as to whether or not these things exist. This defense is going to come in, question those things, put on their case by those statutory.
I think this
We
is
say, well, the jury, we say, well, it's cleaner from the jury's perspective. It's cleaner from our perspective. I don't think we even argued about it. I think the state just went along with it. And I thought it went pretty well. And I definitely want to push back on the idea that, we have a tendency to have these tautologies in the law where we say, well, the jury is great and they'll figure it all out. And so long as we tell them what to do, then they've done what they were told. And there are studies that show that's just not accurate. I mean, there's the jury project. You can read what it's like for people to go through these things. And when we're talking about whether or not somebody's going to be put to death, I think it's important that we really think hard about how these people can make these decisions. If we're going to do a normal, just a penalty section, I definitely think it's something that's going to require some additional instructions. I know the Supreme Court just recently updated a lot of the ICGs, which is great, something that I've been advocating for. But there are additional things that I think are going to have to be told to a jury so that they can understand how that would function. And if you trifurcate it, it's going to make it simpler for them to understand, okay, you've now found this person guilty. Now you're going to be determining whether or not one of these statutory factors exists. This is what they are. This is how they're defined. You have to find this beyond a reasonable doubt. The state's going to do an opening statement and a closing. They'll put on evidence as to whether or not these things exist. This defense is going to come in, question those things, put on their case why those statutory aggravators don't exist. And you're going to make that determination. If you make that determination, then we get to a sentencing proceeding where the state's going to be able to put on any additional aggravators that it wants to put on, and the defense can then put on any other information that they have that's going to be in mitigation. It works, and it worked, regardless of whether or not the SAPD doesn't agree with me. It's well,
It worked, but they didn't disagree. They didn't agree with him. Mm-hmm.
I'd ask the court to consider it. Certainly, if the court decides not to do it, we'll have lots more
Big
conversations.
Blue
about
is still
how best to-
around. Yes, he
It's
is.
an intriguing idea. The concern, of course, is the desire to do this case once and not twice.
I
And
understand.
there's a protocol that has been approved by the appellate bodies versus the one that you're proposing now. And so that's
Boom.
always in a trial judges who tend to be fairly risk averse, difficult.
Yes, sir.
See, he said trial judges that seem to be less risk averse type of stuff. I think that was a dig at Judge, who was very risk adverse. You know, if the defense said something and he was like, oh, you know, I know that this is the way it should be handled, but I'm going to go ahead and hear them out. That was being risk adverse in efforts to only under the law or the thought that you're going to only do this once. You don't want to have to do it twice. Bunch of crap.
Well, thank you.
Thank you, sir.
I'm gonna put this in regular speed because this is gonna be the last thing we talk about in show.
All right. My dance sheet indicates that we have covered all the
Look at old girl here
topics.
wanting to get up. Look at old girl right here.
Your perspectives.
He notices it.
No motions, Your Honor, but I think Miss Massa has one thing.
Housekeeping.
Sure.
Look, his head goes down like, please, not this lady again. Again, she's coming back up here. Like he's looking at her like tired of this
Professor
lady.
Cover.
He does his best to avoid looking at her. She's like,
Indicates
oh,
that
look
we
at me,
have
look at me, look at me,
covered
look at
all
me.
the topics is
Like, look at her, like, I can't get any taller.
Your perspectives.
I can't raise my hand higher.
No motions, Your Honor, but I think Miss Massa has one thing.
Housekeeping.
Sure.
And that's how it ends for the most part. I mean, it's just sit down, Pam. Yes, sit down, Pam. Stop trying to stand up. Oh my God. Yeah, no, I mean, he heard her so much complain about the same thing over and over again after he had already made a ruling. I'm not surprised. He's like, gosh, dang it. Here she comes again. Here she comes again. It is what it is. It is what it is, guys. Well, that was a 2-hour show. Tomorrow night, I'll be back on with It's a Criming Shame. We'll be talking about the Richard Allen case, and maybe perhaps there's a verdict in by then. Make sure you guys go check it out. And then next week, we'll do some more lives, and we'll probably have a member live next week as well. So make sure you join up to be a member. This here case or this here hearing, if this is any indication how the judge is going to take control of it, I have no doubt that this trial will be on time and done properly. I have no doubt. But yeah, I will be back tomorrow night with It's a Criming Shame. We'll talk about Richard Allen and everything that went down. It's an interesting case. It definitely is. But but hit that like button and subscribe. You know what to do. Until tomorrow night, we'll see you guys then. Peace.